For today's video, we will be dealing about the Constitution in general. In particular, we will be talking about the following topics. 1. What is a Constitution? 2. The purpose of a Constitution. 3. The Constitution as a fundamental law. 4th, the Constitution as a source of power. 5th, the types of Constitution. And 6th, the integral parts of a written Constitution. To start with, let us first define the Constitution. What is a Constitution? According to Justice Malcolm, a Constitution is a written instrument enacted by direct action of the people by which the fundamental powers of the government are established, limited, and defined, and by which those powers are distributed among the several departments for their safe and useful exercise for the benefit of the body politics. In other terms, a constitution refers to a system of laws and principles that act as a basis for governance in a country. In light of that definition, we can deduce the purpose of a constitution. So the purpose of a constitution is to establish, limit, and define the fundamental powers of the government by distributing it to the several departments. Additionally, the Constitution also functions or serves as the supreme law of the land. It also establishes the basic framework and underlying principles of government. And finally, it is also designed to protect the basic rights of the people. To proceed, what does it mean when we say that the Constitution is a fundamental law? It means that the Constitution is the basic and paramount law to which all other laws must conform and to which all persons, including the highest officials, must defer. To simply put, the Constitution is the supreme law of the land where everyone, including the government officials, must follow. Under a constitutional government, there is what we call as the doctrine of constitutional supremacy. So what is the doctrine of constitutional supremacy? Under this doctrine, if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch or entered into by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental, paramount, and supreme law of the nation, it is deemed written in every statute and contract. At this point, our next inquiry is the Constitution a source of power or a source of right? To answer this question, allow me to quote this portion of the separate opinion written by Justice Puno in the case of Republic versus Sandigan Bayan. A constitution is not the beginning of a community, nor the origin of private rights. It is not the fountain of law, nor the incipient state of government. It is not the cause, but consequence of personal and political freedom. It grants no rights to the people, but is the creature of their power, the instrument of their convenience, designed for their protection in the enjoyment of the rights and powers which they possessed before the Constitution was made. It is but the framework of the political government and necessarily based upon the pre-existing condition of laws, rights, habits, and modes of thought. There is nothing primitive in it. It is all derived from a known source. It presupposes an organized society, law, order, propriety, personal freedom, a love of political liberty, and enough of cultivated intelligence to know how to guard against the encroachments of tyranny. In other words, even in the absence of the Constitution or of a Constitution, the state would still have powers which is commonly known or which are commonly known as the inherent powers of the state. To proceed, there are two types of a constitution: the unwritten constitution and the written constitution. At this point, let us try to delineate the difference between the two types of constitution. First is the unwritten constitution. An unwritten constitution does not mean that it is completely unwritten, but rather, it is a type of constitution that is not contained in one single document. What does it mean? It means that the fundamental laws and principles can be found in various sources such as statutes, conventions, and judicial decisions. Like customary laws, an unwritten constitution grows from many years of practical experience and from the political way of the people. The classic example of this type of constitution is the British Constitution. The fundamental laws and principles in Britain are scattered in different laws, conventions, and judicial decisions, among others. The second type of a constitution is known as the written constitution. A written constitution is a constitution that is embodied in a single document. Unlike in the unwritten constitution, the written constitution is conscientiously, systematically, and meticulously framed and enacted. Mostly, it is formulated through a constituent assembly, or the Congress, or through a constitutional convention. In the Philippines, we have a written constitution. At present, we have the 1987 Constitution. It is a single document that is considered as the fundamental law of our land. At this point, let us move on to the integral parts of a written constitution. So one, we have the Constitution of Sovereignty. Two, we have the Constitution of Liberty. And three, we have the Constitution of Government. First is the Constitution of Sovereignty. This refers to the provisions pointing out the modes or procedure in accordance with which formal changes in the Constitution may be made. An example of the Constitution of Sovereignty is Article 17 of the 1987 Constitution, which provides the amendments or revisions. Second is the Constitution of Liberty. It is the series of prescriptions setting forth the fundamental, civil, and political rights of the citizens and imposing limitations on the power of the government as a means of securing the enjoyment of those rights. The notable example is Article 3 of the 1987 Constitution, which set forth the Bill of Rights. And finally, we have the Constitution of Government. It provides for a structure and a system of government. It refers to the provisions outlining the organization of the government, enumerating its powers, laying down certain rules relative to its administration, and defining the electorate. The examples under the Constitution of Government are the following: Article 6, the Legislative Department; Article 7, the Executive Department; Article 8, the Judicial Department; and Article 9, the Constitutional Commissions under the Philippine Constitution. The Constitution is important law of the land. Aside from the fact that it limits the power of the government, it also protects the rights of people. Indeed, the Constitution secures political stability and guarantees the protection of liberties.